Good morning, everyone, and welcome to our introduction to the Mandatory Notification of Data Breach Scheme, ensuring your agency is prepared. Before I begin, I would like to acknowledge the Gadigal people of the Eora Nation and pay respects to elders past, present and emerging, and also pay respects to elders past, present and emerging on the lands from which you are all joining us today. In my presentation today, I will discuss some of the features of the New South Wales Mandatory Notification of Data Breach Scheme, what it means for New South Wales government agencies and privacy generally, as well as the work that my office is doing to assist agencies to prepare for the scheme when it commences on November 28th this year. My jurisdiction, of course, extends to New South Wales government agencies, including departments, local councils and public universities. And we have focused this webinar on some of our smaller agencies, including local councils and universities, but we have also opened it up to any staff of agencies who'd like to attend as well. But it really is very much an introduction to the scheme rather than a more detailed look at some of the features of the scheme once you get past the basics. Could I have the next slide, please, Giles? So legislative amendments to New South Wales privacy legislation were passed by the Parliament late last year to provide for the establishment of the mandatory scheme. The legislation also extended New South Wales privacy laws to state-owned corporations that aren't covered by the Commonwealth Privacy Act. And the legislation also removes the particular mandatory notification scheme for Revenue New South Wales under the Fines Act to ensure that all New South Wales government agencies will report under the one mandatory notification scheme once it takes effect. Next slide, please. So the MNDB scheme will require New South Wales government agencies to notify the Privacy Commissioner and affected individuals if there is a data breach involving personal or health information which is likely to result in serious harm. And as I said earlier, the scheme takes effect on November the 28th later this year. Mandatory notification schemes are considered best practice, and a number of schemes have been established in recent years, including the Commonwealth scheme, which was established in 2018. The European Union established a scheme and under GDPR, and there are also mandatory notification schemes in New Zealand and Canada. These schemes enable individuals to take steps to protect themselves in the event of a data breach, such as changing their passwords and being on alert for phishing emails and other scams. They also encourage and require organisations to uplift their capability to manage and mitigate data breaches and work proactively to prevent breaches from occurring. Mandatory notification schemes, of course, are not a complete solution to the challenges organisations and individuals face with data breaches, and particularly with cyber breaches, but they are an important component of a holistic strategy to prevent and mitigate breaches and protect individuals from harm. Next slide, please. So I'm going to start with what is a data breach. And a data breach occurs when information held by an agency is subject to unauthorised access, disclosure, or is lost in circumstances where the loss is likely to result in unauthorised access or disclosure. So perhaps if you think about a case we've seen in the media in recent years where someone might leave a USB stick with work information on it, unprotected, unencrypted, in the airport lounge. And in the past, we've seen that that information has been made public and on occasion even given to the media. Other examples would include paper records of health records dropped in car parks. Unfortunately, we've seen a couple of examples of those in New South Wales in previous years as well. A data breach may or may not involve information that is disclosed publicly. For example, a staff member within an organisation may inappropriately access personal information about one of their relatives held by the agency. A breach may occur due to malicious action, systems failure, or human error, or even a misconception about whether an action is permitted under the information privacy principles. Next slide, please. So on this slide, we've included some examples of data breaches, and under human error, a letter or email sent to the wrong recipient is a very, very common cause of data breaches. The IPC receives regular voluntary breach notifications about these type of breaches. System access could be incorrectly granted to someone without authorization, or there could be inadequate password protection that allows a system to be accessed. And of course, physical assets could be misplaced, as I've just discussed. In terms of system failure, there could be a coding error allowing system access without authentication, or systems may not be fully maintained through the application of known and supported patches. In terms of malicious or criminal attack, I think we're all too familiar with these ways that data can be breached. So cyber incidents through the use of ransomware, malware, hacking, phishing, brute force access attempts, social engineering or impersonation attempts leading to the inappropriate disclosure of personal information, and of course, unfortunately, insider threats where employees or external contractors may use valid credentials to access or disclose personal information outside of the agency. Next slide, please. So we've included this slide from the notifiable data breaches report put out by the Office of the Australian Information Commissioner in Canberra, who is the Australian Privacy Commissioner. The Commonwealth scheme has been in place since 2018, so they have a wealth of data on data breaches. And this is a very interesting graph because what it shows at the Commonwealth level under their mandatory scheme is that some 70% of data breaches are caused by malicious or criminal attack. System faults account for 5% of breaches and human error for 25% of breaches. Next slide, please. And this slide shows the cyber incident breakdown for those cyber breaches on the previous slide. So you can see that ransomware accounts for 29% of breaches, compromised or stolen credentials for 27%, phishing attacks 23%, brute force attacks 9%, hacking 8%, and malware 4%. Brute force attacks are where a hacker might throw thousands of passwords in order to try and break into a system in the hope of landing on one that will work. Next slide, please. So turning now to the provisions of the New South Wales Mandatory Notification Data Breach Scheme, the threshold for notifying under the scheme comes into operation when there has been an eligible data breach. And an eligible data breach occurs when there has been unauthorised access, unauthorised disclosure, or loss of personal or health information, where that loss is likely to result in unauthorised access or disclosure. And a reasonable person would conclude that this would be likely to result in serious harm to an individual to whom the information relates. So you can see that the test is twofold. First of all, that there is unauthorised access, and secondly, that a reasonable person would conclude it would be likely to result in serious harm. So the IPC will be issuing guidelines soon to guide agencies through the considerations necessary for determining whether there has been an eligible data breach and whether the serious harm threshold has been met. The reason we haven't released the guidelines yet is that under the legislation, those particular guidelines require consultation with ministers. So we will very shortly be sending them to ministers for the consultation process. And once we have done that, they will be made available to agencies on our website. And once those guidelines are released, agencies must have regard to the guidelines when conducting an assessment under Part 6A of the PIP Act. Next slide, please. So the threshold for the New South Wales MNDB scheme is serious harm, and we focused on having this as the threshold for the New South Wales scheme because it is the same threshold as the Commonwealth scheme. So this makes it easier for agencies that may on occasion need to report under the Commonwealth scheme, and also for third-party contractors to New South Wales agencies who may need to report under the Commonwealth scheme. So like the Commonwealth scheme, serious harm is not defined under the legislation, but the legislation provides a series of factors that an agency should consider when assessing the risk of serious harm occurring as a result of a data breach. So the harms that can arise as the result of a data breach are context specific, and they will vary based on the type of personal information accessed, disclosed or lost, the level of sensitivity of the personal information, the amount of time the personal information was exposed or accessible, the circumstances of the individuals affected and their vulnerability or susceptibility to harm, the circumstances in which the breach occurred, and the actions taken by the agency to reduce the risk of harm following the breach. So I think a good example of the way you might assess a serious risk of harm is to think about the Medibank breach last year. I'm sure most people on the call are aware of that very significant data breach where Medibank's information was accessed by cyber criminals who then put it on the dark web with the aim of forcing Medibank to pay a ransom to them. So you can imagine in that data set there was health information about members of Medibank Private. Some of that health information was sensitive health information. So while all health information is sensitive, there is some that is even more sensitive. For example, if someone has a mental health issue, if someone perhaps has received treatment for drug use, there are all sorts of reasons why health information could be particularly sensitive. So in a breach like that, an assessor would determine that probably most people in the data set would need to be notified, and in some cases where people would be at serious risk of harm because of the sensitivity of the data, that notification would need to be done very quickly and very sensitively to those people. Next slide, please. So under the MNDB scheme, there are a number of agency obligations. So an agency where they have reasonable grounds to suspect an eligible data breach may have occurred must make all reasonable efforts to contain the breach, assess whether there has been unauthorised access, disclosure or loss of personal information held by an agency within 30 days, assess if there is a likelihood of serious harm to any affected individual within 30 days, and make all reasonable attempts to mitigate the harm done by the suspected breach. Where a data breach is assessed as an eligible breach, agencies must notify the Privacy Commissioner immediately using the form on the IPC website, and notify affected individuals as soon as practical. Agencies must also maintain a public data breach policy, setting out how the agency will respond to a data breach, and a public register of data breach notifications issued by the agency, as well as an internal register of eligible data breaches at the agency. Next slide, please. So if an agency reasonably suspects an eligible data breach has occurred, the head of the agency must assess and decide whether the data breach is an eligible breach within 30 days. This timeframe again reflects the timeframe in the Commonwealth legislation. If the head of the agency is satisfied the assessment cannot reasonably be conducted within 30 days, they may approve an extension of time. But the aim of the scheme is to have breaches assessed as quickly as possible, because that provides the best chance of mitigating the harm to those affected. So we do encourage agencies to complete the assessment within the 30 days where that's possible, and less if that's possible as well. The 30 days is more of a limit, and it's better to complete the assessment as soon as possible. The legislation provides a non-exhausted list of factors that an agency may consider when making an assessment. And the factors are listed also on the slide, and they go to the types of personal information, the sensitivity of the information, whether the information was protected by security measures. So, for example, if the information was encrypted, who could have obtained the information? So whether it was a human error, email sent to the wrong person, or whether it was an attack by a cyber criminal group. And then again, the harm that may occur. Was it a name and address, or was it somebody's identity information, their driver's license and their birth certificate, and any other factors in the guidelines issued by the Information and Privacy Commission? Next slide, please. Once an agency head determines an eligible breach has occurred, they must immediately notify the Privacy Commissioner, and as soon as practical, notify certain individuals. And there are 3 options for notifying individuals affected by a breach. The first option is to notify only the individuals at risk of serious harm, or an agency may notify all individuals whose information was compromised, even if there are individuals in the data set who are not at risk of serious harm. Or if it's not reasonably practical to identify certain individuals, the agency must issue a public notification. Next slide, please. There are some exemptions from notification to individuals. An agency is not required to notify individuals of an eligible data breach if an exemption applies. However, an agency is still required to notify the Privacy Commissioner. This is to ensure that the Privacy Commissioner has visibility about data breaches across the sector. In this respect, the New South Wales scheme is different from the Commonwealth scheme, because under the Commonwealth scheme, if individuals aren't required to be notified, the Privacy Commissioner isn't either. So this is a significant difference between our scheme and the Commonwealth. In some instances, the Privacy Commissioner will receive a written notification when an agency exercises an exemption. The IPC has published a fact sheet on the exemptions to assist agencies to understand how the exemptions work, and this one is available from our MNDB webpage. The exemptions from notification include if there is a serious risk of harm to the health and safety of the individual, or if it will compromise cybersecurity, if it will be inconsistent with secrecy provisions, if an agency has taken action to avoid serious harm, for example, they have recovered the data without it being accessed, if there are ongoing investigations and certain proceedings, such as legal proceedings, and if multiple agencies are impacted by a breach, one agency may notify on behalf of all of them. So in the case of the serious risk of harm to health and safety and the compromised cybersecurity exemptions, those we are issuing guidelines on those two exemptions, but again, we need to consult with ministers on both of those guidelines. So those guidelines will be available shortly once we've finished the consultation process with ministers. Next slide, please. There are a number of other requirements for agencies under the scheme. So an agency will need to review its privacy management plan to update it to include information on the procedures and practices used by the agency to comply with the MNDB scheme. An agency will need to prepare and publish a data breach policy. An agency will need to have a notification register for public notifications, and they will need to have an incident register for their own internal use of data breaches. Next slide, please. There are a number of enforcement powers available under the scheme to the Privacy Commissioner. So there is the power to issue a direction to an agency to provide information where the Commissioner has reasonable grounds to believe there has been an eligible breach and it hasn't been notified. There is the power to recommend that an agency notify individuals of a suspected data breach. There is a power to investigate, monitor, audit and report on the exercise of a function of an agency, including the agency's systems, policies and practices. There is the power to enter premises, observe systems, policies and procedures and inspect documents. And there is a power for the Privacy Commissioner to report and make recommendations. A report may be published, given to the Minister or given to the head of an agency. Next slide, please. There are a number of steps that agencies need to take to prepare for the scheme in November. So agencies will need to establish and clarify roles and responsibilities. So for example, an agency will need to establish who will make the assessment of a data breach to determine if it's eligible. They will need to review and update privacy management plans, prepare and publish a data breach policy, review and update relevant policies and procedures, establish an incident register and a public notification register. The IPC is publishing bi-monthly e-newsletters to update practitioners about new resources and information about the scheme. And there are 3 e-newsletters available on our website already, and they all contain information about different elements of the scheme. Next slide, please. So on this slide, I've listed all of the guidance that the IPC has produced or is producing to assist agencies to prepare for the scheme. So we have a fact sheet on the exemptions from notification. We have a guide to preparing a data breach policy. We have fact sheets for citizens on the scheme, and we have a guide for agencies on managing data breaches in accordance with the PIP Act. And we also have the data breach notification form that agencies will need to use. So all of those resources are complete and available on our website. And then we have the 3 guidelines that require consultation with ministers. So the guideline for assessing an eligible data breach and the 2 guidelines to the health and safety and cybersecurity exemptions. And we hope to be able to put those on the website certainly by the end of September, if not sooner. And we'll also be releasing other resources such as e-learning modules and animations later in the year. In terms of impacts for the IPC, we are doing work across all of our teams to implement the scheme and make sure that we're ready to regulate the scheme. So we've developed workflows, procedures and templates for our case management. We've updated our case handling digital platforms. We've been doing the work on the statutory guidelines and fact sheets for agencies and citizens, getting ready to be able to report on the scheme and developing communications about the scheme. Next slide, please. So I've included this slide because clearly with the scheme coming in, it's very important for agencies to focus on preventing and mitigating data breaches. So the very first important piece that an agencies need, and I will assume that you all have this piece, is a robust data governance framework with policies and procedures covering every part of the data lifecycle, from when you collect the information, how you use it and disclose it, right through to disposing of information when it's no longer needed. A data breach response plan. This is something that agencies will need in addition to the data breach policy that I've mentioned. The data breach policy is mandated under the scheme. The response plan isn't, but it's something that each agency will need to have for when a data breach occurs. And you might have elements of this in your data breach policy, but you will also need to have an internal policy in terms of roles and who will be doing what when there is a data breach. Other ways of preventing and mitigating data breaches. So multi-factor authentication for staff logging into agency systems is an important piece. It was a factor, not the only one, but it was a factor in the Service New South Wales data breach in 2020. Do not use email to store or share personal information. This was another factor in the Service New South Wales breach. Of course, implementing multi-factor authentication and other ways other than email for storing and sharing personal information are big projects. So if that's something your agency needs to do, you will need to commit the resources and the time to do that. But it's very important because, as we know, cyber criminals can get into email through phishing attacks without too much difficulty. Access controls, these are about ensuring that only certain staff can access the information that you hold. You shouldn't have a system with all of the personal information for all of your clients that can be accessed by everyone in the office. It should be divided up so that people can access the system for the information that they're actually working on. And you should also be able to log who is accessing the personal information as well, so that if there is a breach by someone within the agency, you can go back and look at that and determine what's occurred. Email client software is very useful. Sending emails to the wrong recipient is a very, very common cause of data breaches. And while some of these breaches might be relatively minor, within the IPC, we have seen where a simple breach like this can have a significant risk of harm to an individual or a group of individuals. So email client software that can perhaps hold the email back, or make sure that you're checking when you're doing a mailing list that you're putting people in the BCC instead of the CC field. All of these things can help. And the IPC has a fact sheet on email data breaches and how to prevent them. Regular training for staff and contractors in privacy and cybersecurity. And finally, I've put on here, consider third-party risks. We have recently seen the HBL Ebsworth data breach. HBL Ebsworth is a law firm that provided services to government, both state and federal, and as a result of a cyber breach on the law firm, the personal information of many individuals who are clients of state and federal departments has been breached by cyber criminals. So you need to think about your third-party suppliers and how you can ensure that their systems are safe as well. Even though those third-party breaches won't be captured under the MNDB scheme, they will still reflect on your agency, and I know that agencies are very keen to ensure that the public and the people using their services are protected and appropriately notified, even if it's a third-party contractor who has been the subject of a breach. Next slide, please. So on this slide, I've included some links that you may wish to follow up if you want to have a look at the legislation for the scheme. It's on the parliamentary website at the moment and the links are there. As far as I'm aware, it hasn't been included yet in the legislation that you can find online, but I imagine that will happen shortly or at the time when the legislation comes into effect. Next slide, please. And that's my final slide. So I have rattled through that quite quickly, and I know that's a lot of information to take in, but we will make the information available for agencies to look back up on.